8 trade associations and 2 Sacramento County politicians are suing to stop a new anti-pay-to-play law that prevents elected officials from voting on matters involving the people and companies who contribute to their campaigns. Senate Bill 1439, in effect since January 1, requires public office holders, from city councils to school boards, water boards and county supervisors, to recuse themselves from votes and discussions if the official has received more than $250 within 12 months from someone with a financial interest in. Supporters argued the new law, signed by Governor Gavin Newsom in September, ends blatant, but until now legal, influence peddling across the state. But the newly filed litigation against the state's Fair Political Practices Commission, the agency tasked with enforcing it, alleges the law is overly broad, improperly alters the state's Political Reform Act and infringes on constitutional free speech protections related to the right to petition go. The Political Reform Act, passed by voters in 1974, already established similar rules for appointed officers, such as members of boards or commissions, but excluded elected officials from local government agencies. The new law removes that exception. An amendment to the Political Reform Act requires a 2/3 vote of each house of the legislature and must align with the act's purpose. SB 1439 allegedly conflicts with that purpose by attempting to regulate campaign contributions in a way that was not originally intended, according to the lawsuit. The plaintiffs behind the lawsuit include the Family Business Association of California, California Restaurant Association, California Retailers Association, California Building Industry Association, California Business Properties Association, California Business Roundtable, Sacramento Regional Builders Exchange. SB 1439 passed through the legislature without a no vote or any formal opposition. The bipartisan bill was co-authored by State Senator Steve Glazer, D-Orinda and Senator Scott Wilk, R-Victorville. Glazer said he isn't surprised that power interests want to maintain the pay-to-play influence peddling pipeline. He accused the plaintiffs of waiting to file the lawsuit to avoid attention from the public. They were silent during the legislative process, he said. They're trying to protect the financial interests that are attempting to influence these specific local governmental decisions, which this bill stopped. The law does not harm anyone's right to contribute to a politician, Glazer said.